Hello everyone, so far we've done 2 RPC compilation videos, and we're about to dive into the third one. Part 3 of the RPC only has 4 rules, so this is going to be very short. Are you ready? Let's dive in.
Rule 26. Fellowship and Precedence.
Welcome back to the RPC. This is part 3 dealing with your relationship with other lawyers. Let's get into it. Rule 26 talks about fellowship with your learned friends in the bar and respecting precedence. When it comes to fellowship, lawyers have to treat one another with respect, fairness, and dignity. The ill feeling between opposing clients should not influence the behavior between the lawyers conducting the case. At the end of the day, both lawyers should be able to gist and eat rice at the next NBA meeting. No hard feelings. As for precedence, all lawyers in the bar are equal in status, subject to legal precedent rules laid down by law and the long-standing tradition of seniority at the bar. Don't look down on fellow colleagues. Of course, high-ranking lawyers, like senior advocates, are the exception to this rule, as they get privileges like getting their cases called out of turn for mention and motions, or usually out of turn in the court list generally, or sitting in the inner bar. And while seniority matters here, it doesn't justify bullying juniors. And that is it for Rule 26 of the RPC.
Rule 27. Good faith and fairness among lawyers.
Let's talk about Rule 27. This rule wants lawyers to operate in good faith and fairness amongst each other. Subsection 2 of the rule suggests ways that this can happen. If you have an agreement with the opposing lawyer, whether orally or in writing, whether in and out of court, then you have to honor that agreement. If there are some obligations implied from that agreement, be fair and honor it. If you make a promise to do something, do it. Another way to be fair is not to take undue advantage of a misfortune of the opposing lawyer. For example, if the opposing lawyer won't be able to make it to court because of an accident that happened a day before the hearing, and you find out about this, the fair thing to do is to tell the court and seek an adjournment. The unfair thing to do would be to take advantage of the situation by asking the court to go ahead with the matter or to dismiss the matter, as the case may be. This is what is known as sharp practice. Now, there's this common practice where senior lawyers give young lawyers a brief to hold without giving them reasonable time to even understand what the case is about. That is not fair practice, as the chances of an unprepared lawyer fumbling the case in court are astronomically high. And guess who suffers for it? That's right, the client. So unless the receiving lawyer has reasonable time to grasp the matter, then he should not accept to hold the brief. Sub-Rule 4 says that as a lawyer, if you are aware or should reasonably be aware that a person is already represented by another lawyer in a particular matter, don't attempt to snatch that client from the other lawyer. Of course, if that client engages you in a new separate matter, then that's not a problem. That other lawyer would then have the duty of not snatching that client from you when it comes to this new matter you are handling. If you want to have dealings with the client of another lawyer, you have to give that lawyer prior notice. If he accepts, then one of two things will happen. Either the other lawyer withdraws his services, or both of you form a tag team. Whatever is the case, the main lawyer would ensure that the other lawyer gets paid for any work he does. It goes without saying that you can't discuss with the client of another lawyer without gaining prior consent from that lawyer, or if a law permits you to do so. You also can't give advice to a person without legal representation in an ongoing case in court. And that is all for Rule 27 of the RPC.
Rule 28. Associating in matter.
Let's talk about Rule 28. This rule simply states that a client can, either on his own or on the advice of his lawyer, acquire the services of another lawyer to join the current lawyer in the case. Now, where this other lawyer joins, the original lawyer has the right to refuse to this tag team if they don't like it. If the client really wants that lawyer to be in this matter, then that results to the original lawyer being relieved of his services. Or if the lawyer himself withdraws, then a new lawyer can enter into the matter, but that new lawyer has to ensure that the original lawyer has been paid for the work he did. Now, if these two lawyers decide to be a tag team, it's possible that they'll have some disagreement on how to handle the matter. If this disagreement is one that's so serious that it affects the client, it is the client who will have the final say. Now, if after the client has picked a side, the disagreement is so serious that the lawyer who was overruled finds it impracticable to cooperate effectively, then he will have to withdraw from the employment. And that is all for Rule 28.
Rule 29. Change of lawyer.
Here we are, the final rule in Part 3 of the RPC. This rule talks about change of lawyer. When a matter is pending in court, the client can change his lawyer. The client has the right to do so. Now, when that happens, the new lawyer has to give notice to the former lawyer. and also has to make sure the former lawyer is duly paid for what he worked for. Quantum merit. After the change, the old and new lawyer must give notice of that change to the court. It's also good practice for them to serve the notice on the other parties for the sake of convenience. The client is entitled to collect all forms of correspondence from the previous lawyer. These consist of letters written by the lawyer to other persons on behalf of the client, copies of those letters, drafts, and documents made in the course of employment. They are for the client. The old lawyer can hold on to these documents though if his fees haven't been paid. In other words, he's entitled to a lien on these documents until his fees have been fully paid. Finally, the RPC says that this rule is subject to any applicable rule of court. So what that means is that the civil procedural rules of court will take precedence where that same rule of court has provided otherwise. Luckily, many civil procedural rules have provisions for notification of change of counsel. For example, if we look at Order 52 of the Abuja Civil Procedural Rules 2025, the RPC complements it. Notice has to be given to the court, and that notice must be filed and served. And that is all for part 3 of the RPC. In the next part, we will be talking about a lawyer's relation with the court. As always, we are very grateful for you sticking around. Please like, subscribe, and share with your friends. And we will see you next time.